So how do you obtain the status? There are required filings with the IRS. You have to first get an employment identification number, the form SS4. It's fairly basic. It's just outlining who you are, what kind of organization, so that they can decide that you qualify to have the tax identification number. And then you have to either file, depending upon what your current status is, either a 1023 or a 1023-EZ. Depending also on what activities you plan to do, you may also have to file additional filings such as the lobbying expenditure test form 5768 and a power of attorney form. In our firm, we have that power of attorney form filed so that we can communicate with the IRS on behalf of our clients. The IRS will not talk to us if we don't have that form. And again, this is after you've already formed as an organization. So typically, as a nonprofit corporation, you'd have to file with whatever state that you want to be incorporated in. Many organizations choose Delaware as the state that they want to be incorporated in, even if they're not located there. And then depending on where they are, then they would have to file a separate foreign qualification application with the state that says, hello, I'm not incorporated in your state, but I want to do business here. And they'll have to have that in place before they can be able to continue to do business at the state level. They'll also need to have bylaws, and they have to have a budget. All of those things are required if you're doing the full 1023, but we would recommend that you have them also prepared if you're doing the EZ status, because again, depending upon what state you're in, and if you're going to be doing fundraising, those forms will have to be filed with the state as well. As I mentioned earlier, churches are automatically C3s, and they do not have to file the 1023. If you're looking at becoming other than a C3, the 1023 is only for C3 organizations. The other organizations that would seek tax-exempt status would have to file a 1024. So let's talk about the Form 1023. It's a pretty lengthy process, but the purpose of it really is for an organization to demonstrate, one, that it is going to serve the public in some way, and two, it has to satisfy what's called the organizational test and the operational test. So it has to satisfy that it's going to be organized for a C3 purpose, and then afterwards it has to demonstrate that it will continue to operate in that status. And part of underlying that will be for C3, it means that you cannot engage in any activity that would be political, meaning you cannot get involved in any election campaign activity. You can do some limited lobbying. In fact, I would encourage any organization to do some lobbying. You're permitted to under the rules. It just can't become a substantial part of your activity. If you want to engage in lobbying, you should look at becoming a C4 instead of a C3. The form on the organization would identify itself as a public charity or a private foundation, and there is a filing fee. It's based upon what the gross receipts are going to be. It's $850, I believe, if the annual gross receipts are expected to be over $10,000. Otherwise, it's a $400 filing fee. So I mentioned that the purpose of the form is to really demonstrate that you're going to be a public charity, that you're going to organize and operate for that purpose. The other thing I should mention, part of that is too that there's no private inurement to any individual. You can pay compensation to your employees. It's permitted, although discouraged at the state level, to pay officers and boards of directors, but it is permissible as long as it's not excessive compensation. But what that really means is that you cannot have any dividends. You can't have investors who can receive any kind of return on their investment. So when you're filling out the form, these are the sort of the main sections: a statement of activities. What is your estimated actual budget for 3 years? Estimated or actual budget for 3 years? What do you think you're going to be raising and how? Compensation information is going to be important here, and they're going to be looking for additional information about whether or not you're going to have any international activities. Are you going to develop any intellectual property? And they're going to want to know about your fundraising activities. You should include with your application a copy of your organizing document, your articles of incorporation, and it should be signed. The organ should be signed by a principal officer. If you're including your articles, you should document that they actually were filed at the state where you've been incorporated. And usually you'll get something back that has marked filed on it by the state so that you can document that it was actually filed. The bylaws are not organizing documents. However, if they have been adopted, you should include a copy of that. Bylaws, which is a whole separate CLE presentation, but as a general matter, bylaws are your governing document. It says how you will operate. You can probably find simple ones online, but we would encourage, when you're adopting bylaws, to think carefully about how you want to govern yourselves. It is the Bible, so to speak, whenever we're looking at challenges with our clients, particularly if they're having some sort of internal dispute. We have to go by what the bylaws say, and you can think, oh, they're going to be pretty basic and we're going to be good. When you get involved into a legal dispute, you find out that there are a lot of challenges, and so we would encourage that you think carefully when you're adopting the bylaws. In addition, some states have very specific requirements. New York is one of them on what has to be contained in the bylaws. And then unless you're doing the 1023-EZ, as I mentioned, you'll have to include information, financial data about how your organization is going to be funding itself and operating going forward. The effective date of the exemption will recognize that it'll be effective as of the date of formation. So if you formed yourself as a corporation on a certain date, as long as that's within 27 months of when the application was filed and the status is acknowledged, it will be effective back to that date. If it falls outside of that 27 months, then it's going to be the date that they acknowledge the application or the status. If during the time period before you got the status you had to pay any taxes, but you get the retroactive exempt status, you can apply to the IRS for a refund of those taxes. In general, the IRS processes applications in the order in which they were received. However, there is an ability to seek an expedited status. I've never had to seek that. I don't have personal experience in working with it. But if you're a kind of organization like a disaster relief organization, for obvious reasons, if you're starting up something, you need to be able to achieve that status quickly. There is a process in order to be able to do that. So achieving the status has been historically lengthy in the process of doing that. Again, as I said, as long as you get that filed, and I think I misspoke earlier when I said something. The 27 months applies to the date of when you file. So as long as you file within 27 months of when you're formed, the acknowledgement status will be retroactive. So you have to pay attention to the calendar when you file your articles of incorporation so that you get your application filed in time to be able to get the status. The other thing that's important to remember is once you submit that application, you start to become obligated to file a Form 990. And depending upon when your fiscal year ends, that could happen pretty quickly. So you'll want to pay attention to the dates on that. The requirement to file a Form 990 is 4 months and 15 days after the end of your fiscal year. So if you're in a status of a 1231, May 15th would be your initial filing date. You can get extensions up until November of that year, the following year. So because of the delays in processing through 1023s and because of some concerns that were raised by the sector that the process is unduly burdensome, you have a small organization that once they get started, why should they have to go through this whole burden of filing out a full 1023? They came up with a streamlined process called the 1023-EZ. It's effectively a self-certifying form. There are concerns in the sector about the form that some people have raised questions about fraud. I wouldn't say that people would be intentionally engaging in any kind of fraud in using a 1023-EZ versus the full form. But having been involved in this work for a long time, both as a regulator and on this side of it, I think the thing that I've learned the most is organizations don't know what they don't know. And so if you're going to fill out a 1023-EZ, it's not asking all of the same kinds of questions. It's not asking about, well, fully what are your activities going to be maybe, or certain things that will cause you to sort of stop and think, oh, okay, am I going to be doing those things? Am I going to be impacted by saying yes or no when I answer this? If people are doing it without the benefit of counsel, then they're not going to have the benefit necessarily of someone who can advise them properly about what some of those questions mean. And at the end of the day, when you're saying, yes, I certify that I'm going to be acting properly as a 501c3, it's a little dangerous. However, having said that, the IRS is processing numerous of the 1023-EZ forms, and so far they are having the ability of taking a look. They have a follow-up audit process, so hopefully they're going to be catching any of these concerns that I share, as well as anyone who might deliberately try to use the process for fraudulent purposes. And I can think of an example, again, going back to the disaster relief. I think that's where we see a lot of fraud in organizations that crop up quickly, and they could easily say, yes, we certify, we're going to follow the process. They get set up. They get their status, they accept tax-deductible contributions, and then they flee before anybody can figure out what has happened. Truthfully, though, they don't need the 1023-EZ form or the C3 status in order to be able to make that happen. It happens routinely. The challenge for the regulators is when they discover it, oftentimes they've picked up and they're gone. And so trying to catch the people that have done it is challenging. So as a side message, be careful who you donate to after a disaster. So what is the EZ form? Well, it was released in 2013. It allows the self-certification. There are some organizations, however, that cannot use this process. It really is intended for the small sort of grassroots organizations who want to get started and gradually sort of get into the full-blown C3 status. And so it has to be somebody whose gross receipts are expected to be less than, sorry, and in advance for you guys, it has to be somebody whose expected gross receipts are less than $50,000. And they have to have assets of less than $250,000. And this is the most important. You must be formed in the United States and must have a United States address. There is a filing fee associated with this. I believe that is also the same $400 that would be for a full-blown 1023-EZ for somebody who's less than $10,000 on the gross receipts. The IRS had issued a statement in connection with forming the 1023-EZ form, and I think that it's interesting to just read part of it. It said that the IRS receives more than 70,000 tax-exempt status applications for tax-exempt status each year. Thanks to new processes and the 2014 introduction of the EZ, our inventory of applications is current. We've retired the monthly date for average age of pending applications and provided the following guidelines. So at that time, they were suggesting that within 90 days, you could be expect to be contacted, and after 90 days, if you hadn't, you could call a toll-free customer account number. If you submitted an application on Form 1023, they were saying you could be expected to be contacted within 180 days. I think that the 180 days is still fairly routine. We just talked about this at a meeting inside our office the other day, that we're seeing about 6 months on average for the status of a regular 1023 form. I neglected to ask if the 90 days is still holding true for the EZ, but I have to assume that if one is still in place, so is the other.